that a process is arrested, a segment in an election is arrested. So it should not be seen lightly like some magistrates are taking it. It should, a recount has to be with evidence that probably there was a margin of error. That where my vote, the vote was mine, the tick having gone into another box, it was judged to have been for my opponent or to be a spoiled vote. Whether spoiled votes are spoiled, those are the issues. Whether there are a bit of arithmetic errors in the tabulation, those are the things which were meant for that legislation. Not that I would be returning to counting the votes in the entire constituency. That is a recipe for disaster. That was not the intention of the law.
Let us digest now about the law. Let's start on the law that allows the counts of votes. How many days should this be done, and what's the law says about it?
No, it has become fashionable. It has now become a ritual that every person who loses wants a recount. Ordinarily, that law was meant for a small gap, probably 50 votes, where there may be a margin of error. That was the intention of the law. But now it's being misused. You cannot say that you want a recount in the entire constituency like we are seeing nowadays. We are seeing people trying to rig at the election day. When they file, they try the tally center. When they fail the tally center, now they are trying to use courts to satisfy their interests, especially overturning the will of the people. So it is now abusing the intention of matters of recount by court. So the legislators should really look into this. It's good, it's affecting MPs. MPs should go to Parliament and really streamline this law. Courts are not following procedure. Courts are not following the law. Courts are not following, actually, the fact that a recount has to be completed within 4 days. So if we had most of these declarations of winners on the 16th, most of them were 16th. 4 days since 16th was probably even the 19th, because 4 days include the date of filing. If someone probably filed a matter on the 20th, by 24th these matters should be out of court. So you have to file within 7 days. After those 7 days, a matter has to be had within 4 days. Both filing, the replies, the hearing, and probably the actual
decision of the court.
Actual, because there are two decisions here. There's a ruling of court. If the court rules that there should be a recount, then the court reconstitutes itself as a court recounting. It's not now a matter of the Electoral Commission. So if you look at all those processes, it was not meant for example, over 60,000 votes, because it is impractical that you recount 60,000 votes within half a day. If you had a matter in the morning, made a ruling, you cannot. So that was not the intention of the framers of that, but it's being abused. By now, doing a quick math, since the 16th of declaration, if you looked at the 7 days since and the 4 days thereafter, for example, if it was 16, it is very apparent that around the 22nd, you would have had all applications in recounts for members of parliament done within those 7 days. Now, from around the 22nd, you not believe that we can continue having matters now even after the 26th, because the 4 days would have lapsed.
Yes.
Especially that those 4 days include the day on which you have made the application. So all the applications, all the recounts that are coming now beyond at least the 27th tomorrow,
they are illegal.
They are illegal, they're outside the law. But now every magistrate decides the way they wish. So they're exercising their jurisdiction illegally, unlawfully, and injudiciously. So recounts by now should stop. We should be waiting for gazetting of members of parliament. Any recount you hear beyond 27th, beyond 28th is wrong at law. But well, because magistrates are not a court of record, they're doing whatever they want. They're being pushed by political reasons rather than the law.
So what does it mean? It means that someone who will be won or defeated, he will be having a chance to appeal to High Court, or he could just...
No, a recount you do not have
an appeal.
Certain opportunity. You can revise. A decision of the chief magistrate can be revised by the higher court.
Oh.
Yeah, but again, that was not the intention of the law, that you can hold a transmission. A recount, and once an application is made, it has the effect of stopping all processes, including transmitting results to the Electoral Commission, including gazetting. So in governance issues, that is a very serious issue, that a process is arrested, a segment in an election is arrested. So it should not be seen lightly like some magistrates are taking it. It should, a recount has to be with evidence that probably there was a margin of error. That where my vote, the vote was mine, the tick having gone into another box, it was judged to have been for my opponent or to be a spoiled vote. Whether spoiled votes are spoiled, those are the issues. Whether there are a bit of arithmetic errors in the tabulation, those are the things which were meant for that legislation. Not that we would be returning to counting the votes in the entire constituency. That is a recipe for disaster. That was not the intention of the law.
So what is your prayer now? Should all this case should be dismissed?
No court should continue entertaining matters of recount, especially members of parliament who are declared on the between 15th and 16th, because the 48 hours from the date of election were ending on the 16th. Yeah. So somehow we do not believe that people are still filing matters of recount and they are being heard by courts. Courts do not have that jurisdiction to continue hearing such matters. It is wrong, it is illegal, it is unreasonable in an election process. That segment should be closed.
Okay.